Hello and welcome everybody. My name is Georg Winger. It's a great pleasure to welcome you all tonight to this event on AI and VR. We're very honored to have with us tonight Professor Felix Steffek from the University of Cambridge. We will talk about AI and thought predictions, so something we are anxiously waiting for. And just explaining a few of the one thing is that we will, or we are already recording this event because there was a big popular event demand, for being able to watch the event also afterwards. There's also a big online crowd participating, so I hope, by the way, you can all hear me well. The second thing is that it would be great if you could keep questions to after the talk. If there's something immediate that needs clarification, we can ask also during the talk. Maybe that's a good way of doing it, but we'd like to have the presentation as one go, and then we will now publish the discussion for us only lecture itself. So if you have questions for discussion, we have ample time afterwards. Felix will talk for roughly half an hour, and we have a lot of time for discussion afterwards.
Can you please talk a little bit louder, because the sound is very low, so I think we need to...
So we need to speak louder. Yes, sorry about this, but thanks everybody for coming, and over to you, Felix.
Yeah, so thank you very much. So first of all, thanks to Georg and Christoph. It's a great pleasure being here and presenting this Network for Artificial Intelligence and Law Research Seminar. And also, I'd like to say hello to my mentor, Klaus Haupt. I spent 9 years or 10 years at Hamburg at the Max Planck Institute, and Klaus was and is my mentor. And I wouldn't be where I am without Klaus. So thanks a lot. It's great to have you here. So yeah, I will spend the next half hour speaking on legal AI, in particular predicting court decisions, extracting data from court judgments. And I want to speak at the end a bit about large legal data sets.
It's functioning.
So first of all, why am I interested in court predictions? When I started engaging with legal AI seriously 7 years ago or 8 years ago, my academic friend, a computer scientist, Professor Magnussen from the University of Uppsala, asked me, Felix, what's the best thing we could ever do with AI in law? Actually, because he's a computer scientist, he didn't say that what's the best thing we could do. He said, what's the coolest thing we could do? But I thought about it, and I'd say predicting court decisions. Why predicting court decisions? Predicting court decisions does not just matter to those who are actually in court or thinking about going to court. It actually matters to those who are interested in never going to court. Because when we negotiate contracts, when we interact, when we take legally relevant decisions, we often want to know how would a court decide if this ever became a problem. So we are bargaining, as it has been elaborated, in the shadow of the law. So knowing what a court would decide actually means knowing how the law applies to our decisions. And so that is what I would say, one of the holy grails of lawyers. I'm interested in your opinion. What are other holy grails of lawyers? But this is my number one. We also engaged in this research because predicting court decisions has been done in a number of papers, but at the time we did it hadn't been done for the UK. And so we're quite proud to be the first ones to actually predict court decisions using large language models and other models, in particular focusing on UK court decisions. In order to do so, you do need to create data sets, and that is why we engage in extracting data from legal documents. And going back to Mons Magnussen, my academic friend, when I said, let's predict court decisions, then he said, okay, let's do that. And then he said, then we need a data set. And my answer was, well, we don't have a data set. So before we did this, we actually engaged 3 years in constructing a data set, and I want to briefly report on that data set. Now, these are the 3 papers that I will base my presentation on. But this is not just a slide that allows you to read out these papers and what we say there. This is mainly meant to show that this is a team effort. While I'm presenting today, you see many, many names here, and we couldn't do this alone. So we are a team of lawyers, statisticians, AI engineers, data scientists, and we work together in a multidisciplinary way. And without that collaboration, we couldn't do the research that we do. So this is actually to point out and honor my academic collaborators. Let's start with predicting court decisions. We focus on the UK Employment Tribunal. What is the UK Employment Tribunal about? It is the first instance for employment-related disputes. So, for example, we're talking about breach of contract, workplace discrimination, unfair dismissal. The idea of the UK Employment Tribunal is that this is an easy way, after you've tried to mandatorily actually solve your problem amicably, to find an easy way to get justice. You do not need representation by a lawyer. And once you decided you want to go to the tribunal, you download a form, you complete it. And interestingly, this is for those who would know more about English law, the law prescribes a certain structure for the decisions to be taken by the court. I mention that because you will know that UK court decisions are often do not follow a very clear structure. So UK judges generally are not required to follow a certain form. However, the law here prescribes kind of a high-level structure for decisions. We're not talking about decisions such as Supreme Court decisions, where you may have a number of judges, possibly even dissenting. Such dissenting opinions are not written down into the UK Employment Tribunal decisions. The judge sitting may decide not to give reasons, so not to write down their reasons. However, if you are a party, you may ask for reasons. As always in court, you may win or fail, including for procedural reasons. So, for example, if you stop engaging with the court may reject your claims. Here we already look at kind of the core structure of our prediction task. That is, we've got a set of facts shown here in orange. So in that case, Mr. Tarbuck had a complaint about their employer. And kind of so, in essence, what we see is, imagine you sitting in your office, you are a lawyer, and a client walks in and you'd say to the client, tell me what has happened and tell me the truth, summarize this in a couple of sentences, and then I will give you an early indication on whether you may be successful or not in the employment tribunal. The blue part shows what your client wants. So in this case, the claimant made claims for constructive unfair dismissal, age discrimination, disability discrimination, non-payment of holiday pay, and non-payment of commission. So this is what your client wants. And now our task, our prediction task, is what you see here in green. We aim to predict whether the client will win, lose, partly win, or whether another decision will be given. Another decision may be a decision where, for example, where the court requires further evidence. So another decision or other decision is a decision that cannot be classified as a win or lose decision. What's our data set? So we have a good data set, taken from the Cambridge Law Corpus. I'll come back to that later. Starting with more than 50,000 cases from the UK Employment Tribunal. They all sit between 2011 and 2023. In addition, we've got 54 jurisdiction codes. So jurisdiction codes are codes or tags that are associated with these cases. And to give you some examples, they may be something like trade union membership, national minimum wage, harassment, tax, or temporary employment. So these are kind of short explanations on what the cases are about. And there are 54 such jurisdiction codes. Because the tribunal does not always need to give reasons. Some of the judgments are very, very short, so they are one-pagers. These one-pagers do not contain any reasons or facts. So we excluded those one-page decisions from the from our employment tribunal data set, and that left us with 19,000 cases. So you see that there are many cases in which they are just one-page decisions. Now also, for our task, we needed at least facts, claims, and decision. So we excluded from the remaining 19,000 cases those where those three attributes were not present, which left us with roughly 15,000 cases. Now then we moved on to the prediction task, and we were interested in different AI models and how they would perform on the task, and we wanted to compare how humans would predict these cases. So the models we compared are BERT, T5, these are transformer-based models, and then the large language models in the form of GPT 3.5, Turbo, and GPT-4. In addition, we had human experts predicting the cases. So we wanted to see how human experts would do in comparison to these four models. Now, in terms of the large language models, we tried different approaches. We used a zero-shot prediction approach, where essentially you send a prompt to the model and say, these are the facts, predict the outcome. But we also used few-shot approaches. These are approaches where we provided the model with example cases and said, take a look at these cases. These are the facts. These are the outcomes. And now I'll provide you with the case we're interested in. The idea being that the model may learn from the example cases, and we were interested in seeing whether these few-shot approaches would work better than the zero-shot approach. Now, with the few-shot approaches, we tried a couple of variations. In one approach, we gave the model 2 example cases. In another approach, 5 example cases. Also, we compared providing the model with randomly selected cases or cases that came from the same jurisdiction court. In other words, similar cases. So we wanted to see which of these variations would work better. So here's the example of the zero-shot prompt that we used. I won't read it all to you, but in essence, we kindly asked the model to predict the most likely outcome of a case and to classify that prediction as a win, lose, partly win, or other prediction. The few-shot prompt looks very similar. It is just that now in that case, we added, to give you a few examples, here are the facts, here are the claims, and here are the outcome labels of 2 or 5 cases. And now here you've got the case that we want you to predict. So that was the setup for the large language models. Now then we had the humans predicting the same cases. We had 2 human annotators. They were at the level of a PhD student in employment law, so presumably quite good in employment law, I would say. They were supervised by an expert at a professorial level, and they had annotation guidelines, which meant kind of had the aim of kind of streamlining their predictive efforts. They were allowed to consult all sources they wanted to predict the case. However, they were not allowed to research the particular case they were asked to predict. However, given the large number of cases they predicted, and that is 1,371 cases each, you can imagine that they didn't spend a lot of time per case. So kind of roughly, we assume kind of we worked on the basis of spending not more than 2 minutes per case.
Can
And
I ask how they were compensated?
they were compensated by payment in.
By number of cases that they.
No, they were compensated by an hourly payment.
Okay, I see.
Using our standard kind of Cambridge hourly payment for PhD students, because we felt that you couldn't ask someone to predict 1,371 cases without being paid. In addition, we asked the humans to say whether they perceive the case to be hard or not to predict. So each case that the humans considered a hard case to predict, so where they felt they had low confidence in the prediction, they tagged that case as a hard case. Now that was our setup, and now comes the probably most confusing but also most important slide of my presentation, and I will do my best to lead you through it. So, looking at the table on the left-hand side, you see the 5 entities predicting, one of them being humans, and BERT, T5, GPT 3.5, and GPT 4. Now with GPT 3.5 and 4, we only show the version that did best. And for GPT 3.5, that was Juris 5, so that means taken from the jurisdiction, from the jurisdiction cases, so the few shot, providing GPT 3.5 with 5 examples taken from the jurisdiction. For GPT-4, the Juris 2, so jurisdiction codes, but only with 2 examples in best. Then you've got the labels on that we predicted, that is wins, loses, partly, and other, repeating for each model. And then we've got the scores. Let's start with the F-score. So the F-score is usually the most important score because it's a score that balances the data set. And later I will explain that in a bit more detail, what this means, and it will be quite apparent why the F-score is often used as kind of the most relevant score. And if we look at these scores, asking the question who did best, then it is actually the humans that did best for predicting wins and losses. And so here we've got a score of 0.7 and 0.8, which translates to an F-score of 70 or 80%. And that is actually a quite good score. If you would just randomly guess the outcome, you would have an F-score of 27%. So having an F-score of 70 and 80% for predicting wins and losses is pretty good. And you could argue that is something that, for example, a lawyer, would refer to as one part of the information when advising a client whether to try their luck in a tribunal or not. Now, if we look at the other models, then we can see that they're also doing reasonably well, however, with differing scores. If we look at the best score, then we find that T5 does pretty good in predicting losses. Oh.
No, this is when you touch, actually.
Can I reduce it?
Yeah. Better not touch.
Now, let's take a look at some details. While the humans are pretty good in predicting wins and losses, still remaining with the F-score, the humans were not as good as the AI models in predicting the partly wins and the other case. And you can argue that partly win cases and other cases are the more complex cases. Right? So whereas the win and the lose is arguably a clear case, partly win means you win some of what you want in the tribunal, and other means you will not get a win or a loss, but the court will take another decision. And here, for example, GPT-4 does better. So, perhaps one interesting takeaway is that the AI models, in terms of our baselines, do better for the more complex cases. Another thing now, if we go into precision and recall, that is interesting, is that we've got sometimes quite good scores. You know, take the BERT win score of 82, the T5 lose score of 84. These are really decent scores. So, you know, again, kind of if you are a lawyer and you thought about, you know, helping your client using an AI model, then that would be a helpful assistant. However, we also have low scores, right? So if you look at the precision recall and also including the F scores, there's some scores that are really, really low, going up to, you know, down to 0. So we see kind of a mixed outcome, or kind of a mixed baseline to predict, looking at the different scores. Now, let me explain precision and recall a bit more. We can go into this more into the discussion if you're interested, but in short, a precision score is a good score if the cost of a false positive is high. A false positive would be a case where the model says you will win, taking an example, but you will actually lose. So the model gives you a false positive. A false positive would be a relevant score if, for example, you spend a lot going to court. So let's say your lawyer's costs are very high. A recall score is a good score if the cost of a false negative is high. So false negative is, take an example, a case where the model predicts you will lose, but you would have won. That is then a relevant score if, you know, what you would have gotten in the tribunal matters a lot to you, either because the monetary value is high or, you know, emotionally it is important for you to win. So if we take that information, then we can see that the models show a different baseline capability of predicting wins, loses, partly and other. One thing that I'd like to emphasize is that all of these are baselines in the sense that all of these scores could have been improved if we would have put more time, data, or resources into it. And that even includes the humans. So we were interested in this experiment to predict wins, losses, partly wins, and other as a starting point. But this is not the end of our work. And also I'd like to use this opportunity to say that we were just interested in the technical capabilities of these models. What I'm not saying here is that this should be done, or that judges should be replaced, or that this should be used. The ethical question of how and whether this should be used at all is not something we are concerned with or engaging with in this paper. Now, in this slide, this is essentially the same table, but in this case, we have merged the wins and the partly wins. And this is just to show that in that case, the scores go up. And what this shows is that if you're engaging in legal outcome prediction, then the more differentiated you predict, the lower your scores will tend to be. So kind of essentially by choosing how much you differentiate in your predictions, you're already kind of having an impact on how good your scores will be. That was the point of this slide. Now, this slide is quite interesting, I find, because here, you know, we only take those cases that the humans have classified as hard cases. So we were interested in whether the AI models would also have trouble predicting cases that humans consider to be hard cases. Now, the expectation would be that a case that a human would consider to be hard would also be hard for the AI models, and in fact, that is what we see. So the scores for the hard cases are all down compared to including all cases in the table. But now, interestingly, the AI models, in particular T5, outperforms the humans. So for the hard cases, kind of the human baselines are not the strongest baselines anymore. By way of background, perhaps we can go back into that in the discussion later, is that the BERT and T5 are essentially our small models that we trained on our own data, as compared to the large language models, where we essentially just took the large language models that we are offered. And I think that's particularly interesting in the current environment, where there is a discussion whether the large language models will do better than small models trained on particular data. And just kind of in our experience, T5, as a small model that we trained ourselves, kind of outperformed the large language model in that case. Again, emphasizing we're talking about baselines. Now I come to the limitations, because what I've presented has limitations. A severe limitation is that we do not have access to a data set that is similar to the information that parties or judges have before they take the decision. What we did is we took past decisions, we then extracted data and then predicted, or you could say classified, those cases. Now, why did we do that? It's just because such data sets are not available, at least not to researchers such as us. So that is why if you look into the literature on such experiments, you will find that that ex-ante data sets are not available. Interestingly, if you think about what we did is in terms of our facts and claims, and I'll go into that when we look at the data extraction part, we did not cut and paste from the original judgments, but we had GPT-4 extracting data. So we actually listened, or we had the voice of GPT-4 speaking to us. I'll go into the details now, after this. So the automatic information extraction that we use to construct our data set may have had an impact on our experiment. Also, you know, as shown, we used a data set spanning from 2011 to 2023, and we did not in any way trace the evolution of the law. However, what I can say is that UK employment law did not very substantially develop after 2011, so we picked a time frame where we had relative stability of the law. So there are severe limitations. And as you'll see, like, in case you are interested in reading our papers, all of our papers have a section on limitations, because I think it is really key that we are, you know, as neutral researchers, you know, neither leaning for or against AI. We're just interested in what AI does. We want to be very clear and transparent as regards to limitations as we see them. So to conclude, predicting UCAT decisions shows promising baseline scores, both for generative, so GPT, and the non-generative BERT and T5 models. We've seen strong variation between the scores, depending on what we predict. And there are severe limitations on what we do. Now, just a few words on information extraction, which is actually the basis of what I've presented. Why are we interested in extracting information from legal texts? It is actually something that we as lawyers, I assume there are many lawyers in the room, but also others, we daily do. We read text, we engage with text, and we are focusing on particular parts of those texts. Now, before starting the prediction experiment, we needed to construct a data set. So we were interested in whether, in particular, transformer-based AI models or the large language models would do better. So one thing we did is we engaged with our Cambridge law corpus. And I first kind of want to briefly report on an experiment that we did with BERT, so a transformer-based model that is not a large language model, and how that did, and then compare it to information extraction based on GPT. Now, in this case, we said, let's find out whether BERT, a transformer-based model, can find the sentence or half of the sentence in a court decision that contains the outcome. Essentially, we said, look, here is the text of a court decision. Can you find a sentence that contains the outcome? Something like, the appeal is successful. Can you find that sentence in the court decision? Because that is something we would need to do in order to later then construct the data set to train our AI models. Now, if you look at the table at the bottom here, then, and you look at the number of training cases, 388, we had an overall number of 99,565 sentences, but only 536 of these sentences contain the outcome. That means that, in essence, a very, very small proportion of the sentences we have contains the outcome. So only 0.5%. So in this case, in other words, we have a very uneven data set, right? So if we have a data set where essentially almost all the sentences are not the sentences we're looking for, and a very tiny proportion of the sentences are the sentences we are looking for. And now, I will not go into the details here, but essentially here, looking at accuracy and F1, you see why F1 is the more important score for many of these experiments. Because what BERT did in this case, essentially BERT learned to say that a sentence is not the sentence you're looking for. BERT essentially found out that if BERT predicts that this is not the sentence, it will be accurate in more than 99% of the cases. Why? Because it's just one sentence in the many sentences that court decisions have. Now you would think, oh great, that means an accuracy score of more than 99%, that's fantastic. But actually, if you even the data and you look at the F1 score, which is the score that treats the data set as if you had 50% yes and 50% correct no answers, then you see that the model failed to solve that task. In essence, the model did not succeed in finding the right sentence because it just learned to say no, but it didn't identify the right sentence. So in other words, in our case, BERT failed to solve that task. So then, to construct the data set for our prediction task, we used not BERT, we used GPT-4. And we asked GPT-4 to extract 8 types of information. So we thought, looking at facts, so asking GPT-4 to extract facts, claims, references to legal statutes, references to precedents, general case outcome, then general case outcome summarized as wins, partly wins, loses, and other. Detailed order and remedies and reasons would be kind of information that experts, but also citizens would generally be interested in judgment. So here we've got the prompt. I will not go into details. I would just say that what we did is we used GPT-4 to extract that information. And again, we had humans check whether the information extracted by GPT-4 is correct. Because what we're aiming for is kind of having a gold standard against which we can then judge GPT-4 results. And here are the results. The LLM GPT-4, in essence, did really, really well in extracting that information. So if you look at the accuracy here, we've got accuracies of 94% for claims, 98%, 100% accuracy for references to legal statutes and references to precedents, general outcomes 99%. The weakest score was a 91% accuracy for general outcomes in one of the 4 labels. Detailed outcomes 99% and reasons 99%. Because we manually checked 260 cases, we have a confidence interval of 95%. In other words, we are pretty sure of what we are presenting here is correct. And so we could very well use GPT-4 to construct our data set, which we then used to train BERT and T5. So this is kind of the extraction experiment that I'm presenting here, was the experiment that we did before we trained our T5 and BERT data models. 3 more slides, then we're done. Because I want to come back to my kind of the starting point of all of this, because it was literally 7 years ago that one said, what's the best thing we could do? And I said, let's predict cases. And then he said, let's start. And then we need the data set. And I said, we don't have a data set. So actually, before we did all of this, we used kind of 3 years to construct the data set. And I'm quite proud of the Cambridge Law Corpus that we constructed. Because if you want to engage in legal AI research, then you need a data set to work with. The Cambridge Law Corpus is today a corpus of 320,000 cases. It spans 53 courts, 450 years. Most of the cases are in the last part of the 20th century and the beginning of the 21st century. We present it in an XML format. And the good news is that if you are interested in legal AI research, then we are happy if you're using our corpus. So if you Google Cambridge Law Corpus, you'll find a website on which you can apply to get the corpus from us. I get into some of the conditions that we impose on those who want to use our corpus, and I'll explain why we impose those conditions. Before that, I just wanted to list all of the courts and the number of cases that we have in the data sets. This will probably not be legible for those in the room. But what it shows is that once you start engaging, at least that was my personal experience, once you start engaging with law from a data perspective, suddenly the law looks quite different because, as lawyers, we tend to focus on the high courts. We focus on the Supreme Court, the Court of Appeal, the High Court. Perhaps we've got our minds set on some other courts, but suddenly, we see how many courts there are, in particular in the United Kingdom. But also you'll see, that for some of the courts, we've got many cases, and for others, we don't. So our data set is in no way representative or comprehensive. In essence, we make available what we can legally and ethically make available. Now, just speaking a bit about the legal and ethical considerations that we apply. So we have, working together with the Swedish team, I mentioned Professor Magnusson and others, and the Cambridge team, we asked for ethical clearance. The issue with English cases is that people are named and companies are named. And so, there's a lot of sensitive information about people in these cases, and you have to think about what that means if you make such a data set available. As a result, currently we make the Cambridge Law Corpus only available to researchers. We do not make it available for commercial use. We do not make it available to governments. And we require that anyone using our data set does not identify natural or legal persons. We want to avoid that someone uses the research at this point to research what specific people do or don't do. We also ask for ethical clearance of anyone using our data set. We are asking for them to submit an overview, what they intend to do. And we ask them to respect the laws of our country, the UK, the laws of other countries where the legal data set may go. And in order to strengthen this commitment, we ask for a signature of the head of department. These are severe limitations. In an ideal world, we would make this dataset openly available. However, given the legal and the ethical considerations that we apply and the limits that we see, we've imposed these restrictions. I'm happy to discuss them also in the Q&A that we'll have. But just before we go into that, I'd like to say a few words on why we need large legal data sets. From my perspective, access to legal data is an issue of access to law and justice. In particular, court decisions, in my opinion, are public goods. It is ideally someone else and not us would have constructed a large legal data set such as the one that we have constructed, but because no one did it, that is why we engaged with it. I think it is really key, if you look at what scientists do and what academia does, it is key for us to critically analyze what is going on, because otherwise it will just be commercial and public actors that use AI in law. But I think that there's an important part for science to play in making things transparent, looking at what works, what doesn't work, and providing information for the legal and the ethical discussions that are necessary. We see potential for improving access to justice using AI in law. However, there are also risks, and in order to make sure that these innovations and in a highly competitive environment that we currently see are done in a responsible way, that is why we engage in the research that I've presented. With this, I close. Thank you very much again for having me, and I'm really looking forward to this.